The question is that the bill be now read a second time. Mr Sadiq Khan.
Thank you, Mr Speaker. I note the time, and I normally allow all interventions, but I'll try and observe your stricture on constraints with regard to interventions. I know this bill is heavily subscribed by colleagues who want to speak. Mr Deputy Speaker, the government's approach to criminal justice is in tatters. We have a hodgepodge that does nothing to win the confidence of victims, the people in the justice system and the public at large. This bill is controversial as much for what's absent as what's found its way in. Key areas of policy which were consulted and are absent. Some are to be subject to further review, while some clauses have been included in issues which we were not consulted on at all. The Lord Chancellor knows as well as I do that within weeks, if not days, of this bill moving into committee stage, there will be a flood of new amendments and new clauses. After 13 months, 3 green papers and 3 consultations, there is no excuse. Last week, the Prime Minister unveiled the Justice Secretary's legislation in his absence. A number of eye-catching proposals were announced on squatting, self-defence and knife crime. The favourable coverage were precisely the aim of the Prime Minister. Suddenly, because of the Prime Minister's last-minute intervention, the bill was being spun as being tough on crime. Even the words punishment of offenders found their way onto the name of the bill. But we ought to be clear up front. The clause in this bill on knife crime is still a Conservative broken promise. It's not what was promised in their manifesto. This new offence of aggravated knife possession carries a mandatory 6-month sentence, but applies to a much narrower category of cases than those caught carrying a knife. Aggravated knife possession is using a knife to threaten someone. It's already a crime. The sentencing guidelines already recommend a minimum sentence of 6 months. It's not even properly mandatory. A court won't have to hand down the sentence. It will be up to the judge to decide, given the circumstances of the case or the offender. Now, Mr Deputy Speaker, knife crime is a persistent and worrying concern. It does impact particularly on young people and the disadvantaged. It's not clear how this hollow proposal will help those communities blighted by knife crime. 2 other headline grabbers, squatting and self-defence against burglars, aren't even in the bill. But as the Justice Secretary has admitted today, the provisions of self-defence won't even be a new law, just a reiteration of the existing law. It's a rather depressing story that's been repeated since May 2010, a string of broken promises on criminal justice. Before the election, there was a commitment to match Labour's prison building programme. Instead, spend has been slashed to virtually zero. The Tories promise maximum and minimum sentencing, now also ditched, and the electorate were promised that those caught carrying a knife would face the presumption of jail, but what we've been presented with is entirely different. And can I deal with an accurate picture of our record? The Justice Secretary inherited levels of crime 43% lower than they were in 1997. Crime went down under Labour. He inherited a system with a greater focus on diversion for those with mental health and drug dependencies. He inherited a capital programme upgrading and expanding our prison estate. He inherited innovative payment by result schemes, including the one he now boasts about in Peterborough. And re-offending, particularly amongst young people, fell under Labour thanks to investment in effective intervention programme now threatened by his government. This bill risks all this progress. And it's generated an impressive coalition opposed to the plans, from the judiciary, victims groups, legal organisations, charities that act on behalf of some of the most vulnerable in society, from some of his own backbenchers, but not from, I note, the Liberal Democrats. Briefing note after briefing note after briefing note from organisations as diverse as Scope and Justice demonstrate the Prime Minister's perceived rescue of the Justice Bill is fooling no one. I support penal reforms, but these are the wrong reforms. Carelessly thought out, badly framed, confusingly argued, weakly handled and grossly under-resourced from the start. It will be the communities around the country that will suffer.
I'm glad to hear the right honourable gentleman is in favour of penal reform. He hasn't, so far as far away, put forward a single suggestion in the area. Could he give us 1 or 2 examples of the Liberal reforms that he has in mind?
Mr Speaker, he will be aware of our programmes in relation to mental health. from the Bradley report, which started and which he's now agreed to follow with the reduced budget. He'll be aware of the work done by Corsten in relation to diverting women away from prisons. He'll be aware of payment by results. He knows about the work that begun, which he's under-resourced in putting our strategy at risk. Mr. Deputy Speaker, I'll give way in a while. I want to make progress because time is short. Shambolic last-minute changes to this bill have left a £140 million black hole in his plans. The Prime Minister has said this money will need to be found from within the MOJ budget, and the Justice Secretary admitted this morning that he's not sure where he'll find this money from. This House needs to know the exact details of this. The progress of the bill depends on knowing where this money will come from and what implications it might have on other areas of spend. And why do we have this problem? Well, it's because the Justice Secretary simply failed to argue his corner with the Treasury. We know that he boasted he didn't wish to be involved in, and I quote, a macho contest with Cabinet colleagues over who could have the smallest budget cut. And the figures are testimony to just that. His budget cut of 23% is one of the biggest in Whitehall. As a result, we have heard him justify his ill-thought-out policies and his cuts to prison, probation and legal aid budgets, all stemming from his lackadaisical attitude towards the Treasury. He needs to realise, Mr. Speaker, he's no longer the Chancellor, he's the Lord Chancellor. A justice policy retrofitted around his prison population reduction target, in turn driven by the 23% budget cuts. Our justice system deserves a better advocate. Okay, wait for I move on.
Thank the right honourable gentleman for giving way. Can I just remind him that in November he said, "Let me be clear, had we been in government today, we too would have been announcing savings to the legal aid budget." Would the honourable gentleman set out precisely where those savings in the legal aid budget would come from?
Mr. Speaker, I've done that before and I'll do that again in a little while. I'm happy to answer that question. I'm really happy to. Can I move on to remand? His remand policies demonstrate how budget cutting is taking priority over what's in the best interest of our justice system. Defendants will not be remanded in custody where there is no real prospect of a custodial sentence being handed down. The government's own Victims Commissioner, Louise Casey, says that, and I quote, victims groups during consultation have expressed alarm at these proposals. The Magistrates Association and the Sentencing Council have also expressed opposition, and I want to quote the Sentencing Council, who say, in some cases it will not be clear until the conclusion of the trial or the preparation of the pre-sentence report whether the offence in fact merits a custodial sentence. They remind us the primary reason for remanding a defendant in custody is that he or she will fail to attend court, or there is risk of further offending, and or there may be a good reason to believe that the defendant will interfere with witnesses. This change, does he not realise, is likely to deter witnesses and victims coming forward. And Lord Justice Thomas and Lord Justice Goldrin both raised the genuine concern that and I quote, the decision as to whether to grant bail or not is quite separate from the decision as to the eventual sentence. Yet these concerns have been ignored. In this chamber last week, he said he paid particular regard to the legal opinions that he was getting from serious members of the judiciary and others when ditching his 50% sentence reduction proposal. It's disappointing. He's not only ignored Lady Justice Hale, but he's also not listened to the concerns of the senior judiciary and others on this particular policy as well, and not removing it from the bill. And Mr. Speaker, I want to move on to his policy on IPPs. Indeterminate sentences for public protection are notable by their absence from this bill. Another example of the shambles he's in. The Justice Secretary has talked of the need to reform the system of IPPs, use of which had mushroomed well beyond their original purpose. IPPs do have a role as they were originally envisaged, and I acknowledge the efforts of my right honourable friend, the member for Blackburn, in his reforms of IPPs. This government's proposed a new approach to IPPs in its Green Paper, which were subsequently consulted on, as has been said, and they favoured raising the minimum tariff to a 10-year determinate sentence before an IPP can be enforced, a level beyond the length of sentence handed down for violent and sexual offences, including rape and assault. And we were opposed to this. However, there is now nothing in their bill whatsoever about this, and the Justice Secretary has today confirmed he will be getting rid of IPPs, but he has also announced an urgent review. Has he not already preempted the outcome of his review? And I'm afraid, in response to my honourable friend who raised the interesting point about learning lessons from Northern Ireland, well, he won't, because he's already made up his mind, I'm afraid, putting cost over protection of the public. Mr Deputy Speaker, Labour's position on IPPs is clear. Offenders must be punished and reformed. They must not pose a risk to the public, and proper due process must be followed before they are really supported by courses and programmes and an effectively resourced parole board allowing rehabilitation to take place. We won't accept plans that water down the protection given to the public by IPPs. We believe there is a continuing role for IPPs reserved for very serious and violent offenders, those who are the biggest risk to the public, as was their original purpose. His solution appears to be mandatory life sentences for all those deemed to be a serious danger to the public if released. He's got no idea if this will lead to the prison population going up or down, no ideas of what he's going to do about those who've served the minimum tariff who are on an IPP. Why is he so unwilling to invest in programmes, courses and the parole board to address offender behaviour? Mr Deputy Speaker, the absence of IPPs from the bill has created further questions about his budget. As a result, the impact assessment is incomplete. Moreover, the Prime Minister last week appeared to announce more policies, more mandatory life sentences, longer determinate sentences, and that serious offenders will serve at least two-thirds of a sentence. But these proposals are also absent from the bill. And given that one of the causes of the backlog in IPPs is due to a shortage of suitable courses and resources for the parole board, how does he expect the two-thirds sentence proposal to avoid running into exactly the same resource issues as IPP's utter shambles? Moving on, Mr Speaker, to the important issue also of legal aid. Look, our legal aid system was established as a fundamental pillar of the post-war welfare state. Clement Attlee's government rightly recognised that equality in the face of the law should not be undermined because of lack of finance. Therefore, it is bitterly disappointing that the bill has only minimal changes to the cuts proposed on the Green Paper. And I accepted on the day the Green Paper was published that we too would have made cuts to the legal aid budget. However, I asked him to look again at the areas he was targeting, but he hasn't. As a result, the weight of opposition to the proposals remains huge, damned by the numerous campaigning groups representing some of the most vulnerable people in society, the 31 charities that wrote last week to the Times in protest, the Law Society, the Bar Council and other members of the judiciary, yet he's ignored all their concerns. Well, I'll let him know right now our views on legal aid. We oppose the cuts to social welfare legal aid, the kind of early stage advice provided by law centres and CABs on issues like debt, housing, welfare benefits and education issues, because of the disproportionate way this will affect the most needy in our society. The result, as the campaigning group Justice have said, will be the economic cleansing of our civil courts. Some estimates suggest over 700,000 people will have their access to justice taken away, and all this compounded by the disproportionate impact of the proposals will have on women, in particular in the definition of domestic violence. Once again, this government is hitting women the hardest. Of course I will.
Very grateful for my right honourable friend. But does he agree with me that one of the problems that the government has so far completely failed to address is how we ensure the sustainability of the law firms, the law centres and the practices across the country? That it's not just a question of individuals losing their service, it's the fact that those centres, that provision, is going to be undermined and in many cases faces collapse.
My honourable friend is right to remind the House that if we're not careful, the whole country will become an advice desert for the poor and the vulnerable as a consequence of this policy. And in government, we always strive to protect social welfare legal aid. Our March 2010 proposals, strangely ignored by this government, would have generated savings sufficient to protect social welfare legal aid. His changes will have a huge impact on the viability of many law centres, CABs and high street practices up and down the country that do an enormous amount to provide access to justice for some of our most deprived citizens. You know the irony? This is the time when they need that advice the most. A whole swathe of society losing their ability to exercise their legal rights, with women being particularly affected. And the Lord Chief Justice has warned that the proposals will damage access to justice. The CABs have warned these cuts will leave hundreds of thousands with nowhere to turn for help. And it's the CAB who have demonstrated the savings to the taxpayer down the line as a result of early intervention. £1 of legal aid expenditure on housing advice saves £2.34 to the state. On benefits advice, the saving is £8.80. There is a moral and economic case not to cut in this way. And as he knows, the Lord Chief Justice has warned that cuts to legal aid risk a surge in litigants in person, with all the associated increase in stress and cost that will entail as a result. And can I deal with the point touched upon by the honourable member for Enfield Southgate? He'll have a chance to wind up. We've now got less than 4 hours. He'll get a chance to wind up. The honourable member for Enfield Southgate touched upon an area of real concern. Clause 12. Clause 12 seeks to loosen the systems which guarantee free access to a solicitor upon arrest, established in the 1980s when the Justice Secretary was in government, on the back of a number of high-profile miscarriages of justice cases. He has failed to justify to the House, except that it was a Labour idea, why he's seeking this change. It should be deleted, and when he winds up, his colleagues should say it will be deleted before it gets to committee. Mr. Speaker, on civil litigation, the government's proposals are primarily driven by their zeal to fix the so-called compensation culture. But by cherry-picking the Jackson Report recommendations, this bill runs the risk of undermining access to justice, something which the introduction of no-win, no-fee sought to guarantee, and will scrutinise these clauses closely. Mr. Speaker, the Secretary of State has... I won't give way to him. Mr. Speaker, the Secretary of State never had a credible strategy for achieving his rehabilitation revolution. His plans are fatally flawed and always were. He's demonstrated he's not on the side of victims. His use of language on rape sentencing, his original 50% sentence reduction proposals, and the reduction in the use of remand in custody show that there's no sense he understands that victims and witnesses need to have confidence in the justice system and feel it's safe in his hands. By taking away from the judges the ability to remand in custody in cases they think appropriate, and by abolishing IPPs, he's not explained how he'll give judges the tools they need to keep communities safe and cut crime. And I will.
Grateful to the honourable gentleman for giving way. Would you just want to comment on the move towards more mediation in family courts? Because that is a very important area, and I think it is something which should be welcomed. I don't know if he'd agree with that, but it is one of the central provisions in the bill.
Mr. Speaker, I'm happy in the short time to welcome that proposal. I mean, he'll of course be aware what we need is some investment in training mediators. I mean, it's all well and good trying to divert people away, but we hope his government will train more mediators. Mr. Deputy Speaker, the government's figures just don't add up. Overall, 10,000 prison and probation staff are going to lose their jobs. Yet he expects much more for less. More rehabilitation, more treatment for those with mental health problems and drug dependencies, but how will it be funded? A chunk of his savings were due to stem from a lower prison population, but given the way his bill has been filleted of its ill-thought sentencing proposals, where does he think the prison population will be in 2 years' time? Higher, lower? I look forward to the wind-up to hear what the government's idea is of this. The debacle that is his bill has shown up this government's justice policy for what it is: incoherent, inconsistent and obsessed with cutting costs. It's a shoddy bill and doesn't focus on what works to cut crime, protect the public, reform offenders and put victims first, nor will it continue to ensure access to justice for many of the most vulnerable in society, particularly women. He's failed to accept the alternatives offered to make savings to the legal aid bill and stuck to his original plans, which will have a devastating impact on the most vulnerable in society. Mr. Deputy Speaker, there will be many MPs on the government's benches, no doubt, speaking in favour of this bill. I gently remind them that last month, when we had a motion to remove the 50% sentence discount, many of them were marched up the top of the hill by the Grand Old Duke of Rushcliffe, only for a humiliating march back down a couple of weeks later. All those loyal contributions which some of you made, no doubt you now regret. I hope they will think very carefully, Mr. Speaker, about how they vote tonight. One thing's for sure, we intend to vote against second reading of this shoddy bill. Yeah.